Welcome to the video on violence risk assessment. The objectives today are going to be identifying the nature of violence and purpose of risk assessment, describing the history and the development of risk assessment, understanding the differences among risk assessment, understanding issues that impact accuracy of risk assessments. The primary focus of forensic psychology and law. What do you think it is? If you had to guess, go ahead and think about that. The answer is it's evaluating the violence potential of an individual. All right, so when courts determine the sentence for an individual, they often rely on pre-sentence investigations. These investigations assess the likelihood of an individual committing another violent offense in the future. The dangerousness is a specific requirement for one legal process civil commitment. Blank and blank decisions, or even the level of supervision required for someone released from incarceration, are based on determination of that individual's risk of violence. So basically, this area of law enforcement help the courts determine if through pre-sentence investigations, help the courts and help the judge determine the dangerousness and risk assessments. So what do you think? Who is that? What part of law enforcement does those investigations and does those risk assessments? Parole and probation decisions, or even the level of supervision required for someone released from incarceration, are based on determinations of that individual's risk of violence. All right, so before those determinations are made, whether to transfer a juvenile to an adult court or not, or an evaluation of future violence tendency is likely to occur, schools, businesses, and governments are assessing the potential for violence among students, employees, or people who threaten government officials. Over the past several decades, there have been a number of important legal and psychological changes that have drastically advanced the field of risk assessment, which is what we're talking about right now. So legally, the courts have made it very clear that they value and rely upon violent risk assessments in making a host of legal determinations. Despite the limitation of these risk assessments, empirically, the literature has made amazing progress from making a more concerted effort at identifying the relevant risk factors to devising structured actuarial approach to assess violent risk. So, what is our definition of violence then if we're going to put so much credence in these risk assessments? According to Hart, violence is actual, attempted, or threatened physical harm that is deliberate and non-consenting. This definition of violence does exclude potential forms of violence such as emotional violence or verbal violence. So you say, what? Emotional violence seems to be less relevant in many legal situations. Violence, they say, is a choice. So the proximate cause of violence is a decision to act violently. Many people struggle with the idea that violence is a choice. To give you an example, it makes sense that if someone gets out of her car because she's been cut off in traffic, such as road rage, and uses a baseball bat on the offending driver's windshield, the behavior to act that way is a choice. But what if the baseball bat wielding driver has been drinking? Was the behavior still a choice? Makes you think, huh? Legal realities of violent risk assessments. In the case of Barefoot versus Estelle, 1983. The case of Barefoot versus Estelle, let's look at the facts of the case. The defendant, who had been convicted of murder, had experts testify of his ongoing risk to be violent, so risk assessment. Based partially on this testimony, the court handed down a sentence of death for Barefoot, based partially on the inaccuracies of the risk assessment at the time he was given. In Shaw versus Martin in 1984, a lawsuit was brought on behalf of a group of juveniles in New York. The juveniles were routinely held at the discretion of the judge if it was deemed that they would not return to court or if they might commit a crime upon release. So these were all on risk assessments. There's some more important cases you'll find in the assigned reading. History of risk assessments. So there's actual history we can look at of what has been done in the past. The first generation of research in the 1970s of risk assessments were so poor that some called for the abolishment of civil commitment. The studies that were conducted focused on poor predictor of violence, enabled poorly measured and defined violent outcomes, used narrow samples, and were poorly organized. A host of improvements to remedy the problems on violent risk assessments were made. Clinical assessments of violence. Even though clinical assessments of violence have been the norm in forensic psychology, clinical judgment has often been disparaged as informal and subjective. Early research on the accuracy of clinical judgment was even the basis for much the pessimism regarding forensic psychology's inability to assess risk accurately. Studies by early pioneers that suggested that forensic psychologists could clinically predict only 20% to 35% of patients accurately were all that existed over 30 years ago. Actuarial measures of violence. As risk assessments advanced, the third generation of research marked the beginning of actuarial measures of violence. Actuarial approaches contrast with clinical approaches in that they tend to be more formal, algorithmic, and objective, and has a statistical basis. The second generation of risk assessment focused on the idea of potential risk factors and served as a basis for the later development of actuarial and structured approaches to risk assessment. There's a really great case that talks about risk assessment and an actual test that didn't work very good. And it's kind of a scary case with a link under Moodle that I want you to view. All right, we'll see you for the next video series.